Well, good morning, everyone. It is my pleasure to call this meeting of the Texas Commission on Environmental Quality to order. Today is Wednesday, September 22nd. The time is 9:30 a.m. With us today are Commissioner Bobby Ginecca and our General Counsel, Mary Smith. I'm John Neerman. Commissioner Lindley is on maternity leave, and we are just delighted for her and her family. This meeting is a hybrid meeting in that most of the participants are joining us virtually. So please keep your microphones muted when you're not speaking. And if you're here only to listen, you can do so online, and that link is available on our agenda notice. For each item where argument or discussion is allowed, we will inform speakers of their time limits. The registration is now closed, but if you'd like to speak on a particular item, please email agenda@tceq.texas.gov with your name, your affiliation, and the item number you'd like to address, and we will do our best to accommodate that request. For those making presentations, please wait to begin until either I or our General Counsel have asked you to do so, and do remember to unmute your line before speaking. And with that, I'd like to thank everyone for being present today here in the room and virtually. And Ms. Smith, I'll ask you to please call the first item.
Item number one is the application by Land Passes Trucking and Ready Mix LLC for issuance of air quality standard permit for concrete batch plant registration number 162529. The parties have been notified that the commissioners will not take oral argument, but may ask questions.
Thank you. So for those who are not familiar with our process on contested cases, we have a two-part analysis for considering those requests. First, we consider whether the requester has met the procedural and substantive requirements to be entitled to a contested case, and assuming that at least one requester has done so, we then consider which issues should be referred over to a hearing. So part one is about who gets a hearing, and part two is about which issues are referred. Requesters who are affected in a manner different from the general public and who have articulated a personal concern that is relevant and material to the permit and has done so both in timely comments and a timely hearing request are entitled to a hearing. Now, with respect to who's an affected person, somebody who's affected in a manner different from the general public, Section 382.058C of the Texas Clean Air Act specifies that only those persons who are actually residing within 440 yards of a proposed concrete batch plant may request a hearing. And Commissioner Ginecca, on this item, we had over 30 hearing requests. Overwhelmingly, they were from people who reside beyond 440 yards. Other requests failed because they were not paired with timely comments, or they failed to provide a physical address. And two of the requesters unfortunately passed away, and I think we'll take judicial notice of that fact based on their death certificates. So ultimately, I found just one requester that meets the procedural and substantive requirements to be entitled to a contested case, and that request was submitted by Conway Jordan on behalf of Don Jordan. Don Jordan resides in a nursing home that is within 440 yards, and so I would grant his request. As for the issues, I would refer just to whether the draft permit is adequate to protect the health and safety of the requester, and whether it adequately protects against nuisance dust conditions that may affect the requester. And I think the last couple of elements of the motion would be to allow 180 days for a hearing duration and to include an ADR referral. So let me toss that over to you and let you unpack it, or?
I'm in agreement across the board. I think you've hit every relevant factor there. I reached the same conclusion with the requesting parties who are entitled to effectiveness, and I'd be comfortable making that motion.
Great.
I move that we grant the hearing request of Don Jordan, deny all remaining hearing requests, and refer the application to SOA for a contested case hearing on the following issues. 1, whether the draft permit contains adequate conditions to protect the health and safety of the requester. 2, whether the draft permit contains adequate conditions to protect against nuisance dust conditions that may affect the requester. That we refer the matter to the Commission's alternative dispute resolution program to run concurrently with SOA's scheduling process, and that we set a hearing duration of 180 days from the date of the preliminary hearing until the proposal for the decision is issued.
Thank you. The motion has been made. I second it. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, please call the next item.
Item number 2 is the application by the City of Granbury for new TPDES permit number WQ 001-582-1001. The parties have been notified that the commissioners will not take oral argument but may ask questions. Those who have signed in will be noted for the record.
So again, we follow the same two-part analysis for considering these requests. Part 1 is about who gets a hearing. Part 2 is about which issues are referred. Requesters who are affected in a manner different from the general public and who have articulated personal concerns that are relevant and material to the permit and have done so both in timely comments and a timely hearing request are entitled to a hearing. I counted about 17 timely requests in this case. So Commissioner Janica, let me start with the easy ones. Bennett's Camping Center and RV Ranch is adjacent to the proposed facility. It raised personal justiciable issues and met the other procedural and substantive requirements. And similarly, the RV Ranch property owners, and that is Stacy and Jim Rist, met the requirements. So I would grant those requests. Ronnie and Diane Hasty reside across the street from the proposed facility, and the discharge route would run through their property. The Hasties expressed personal concerns, including about the health effects, and met the other requirements for hearing, so I would also grant their request. Judith Gagliardo also resides adjacent to the facility. She's leased a space in the RV park for the last 2 years. She's shown a personal justiciable issue and has met the other requirements, so I would grant her request as well. Walter and Victoria Calder reside next to the discharge route within 1 mile of the proposed facility. And given the size of the proposed discharge, which, just to remind everyone, is up to 2 million gallons per day, and the Calder's proximity, I think that they have also expressed a personal justiciable issue. And their concerns that they expressed in their request includes concerns about health effects. So again, I would grant their request. And really, the
Chairman, just to
Yeah, go
clarify
ahead.
for you, that was Walter Shaw and Victoria Calder?
Um,
I wasn't sure. I may have misheard you and referred to both of them as,
You know
as the
what?
Calders, but I just wanted to confirm.
I did refer to both of them as the Calders, and I'm mistaken. It is Mr. Shaw and Ms. Calder. So Walter Shaw and Victoria Calder. So with apologies to Walter, I'm going to continue on here. There were several folks who were situated similarly to Mr. Shaw and Ms. Calder, and those are George and Cynthia Griffin, Kay and Bud Loak, Susan and John Michi, David and Kathy Montgomery, Keith and Colleen Nielsen, and Jason Nolte. And so for the same reasons, I would grant their requests. John and Doris Faber are a little bit of an interesting case. They also expressed health concerns. They're similarly situated on the discharge route. They're just slightly more than a mile from the proposed facility. They reside within about 150 yards of the 1 mile radius. But again, given the size of the proposed discharge and their proximity, I believe that they also have a personal justiciable interest that is an interest different from the general public, so I would grant their request as well. Little bit different set of facts for Deborah and Peter Cook, Woody Frossard, and Paul Williams. They all live within a mile of the proposed facility, but they do not live on the discharge route. Each of them, however, did express a concern about nuisance odors. And once again, given the size of the proposed discharge, I believe that their concerns are likewise personally justiciable. So I would grant their request too. And I believe that leaves just 2 requests. The first by Cynthia and Norman Gookins, the second by Crystal and Dick Lehman. The Gookins live about 1.25 miles from the proposed facilities, and the Lehmans live just over 1.75 miles away. And these were somewhat of a closer call for me, Commissioner. So I think I'm going to follow the unanimous advice of the Executive Director and the Office of Public Interest Counsel and recommend that we deny those requests. So, so that's how I came out on the requesters. Let me pause there and gather your thoughts.
I appreciate that, and I think I was with you right up until the very end, and that's the last two pairs of requesters, Norma and Cynthia Gookins, and Crystal and Dick Lehman, and they fall just a little over. I think the Gookins are approximately 1.25 miles from the facility, and the Lehmans are about 1 8/10 mile. I found that for the Gookins in particular, there were compelling arguments for their effectiveness in the location and the quantity of the discharge in this instance. I think it's always a case-by-case basis, and I'm sensitive to where it falls close to the line that tends to be about a mile out from many facilities, but there's no rule of thumb and there's no hard rule. And so I appreciate that your inclination is to to fall with Executive Director and Office of Public Interest Counsel's findings on those requesters. I'm comfortable with that. I'm not opposed, and I also would be fine moving them along as affected parties, frankly, because it doesn't further materially change the issues that end up before SOA for later discussion. So that's my thinking.
So you might suggest to include the Gookins in the referral, but deny the Lehmans.
That was my nuanced surgical slice, my best attempt at it in trying to understand and observe what I believe to be the Commission's practice in really regarding these issues on a case-by-case basis. And I found this amount of discharge to be a little more on the higher side rather than the lesser side in this instance, and that helped push my comfort level in finding the Gookins to be affected.
Yeah, and I understand that. I think it's reasonable. I actually don't feel real strongly about it. I'm kind of on the bubble and was looking for some hint to push me one way or the other. So long and the short of it is I would be fine with that. I mean, we're given really a challenging task of deciding what's the difference between a personal justiciable interest and an interest that's common to the general public, and it's not a bright line standard. It's a very difficult standard to apply. And
not at all. In my mind, some arbitrary number of 1/4 mile, 1/10 mile, 2/10 mile doesn't really change the factor that someone living in a place next to a body of water, a place of clear outdoor recreation, that's a really compelling argument in my mind that's they're moving up the creek, and I buy that argument very, very strongly. So
okay, well, I'm fine with that recommendation.
Great.
Okay. Issues. Are we ready for issues?
Proceed.
Okay. I have a long list of issues, and my hope is that we may have come out at more or less the same place. So I'm going to punt a little bit on this and propose the following. I'm going to suggest that you, assuming you have a motion prepared, read a motion, and I will, as you're reading that, track to see how it's mapping up to the issues that I've identified. And then we can talk about it on the other side.
I love it. Let's get a motion out, and then we can.
And before you dive in,
it.
I would again include a 180-day hearing duration. And also, there were some requests for reconsideration that I think are, I guess mooted because we're referring this over to SOA. They didn't really raise any new issues, so I would deny those in a motion as well.
I think my motion should capture that.
Okay.
Let me proceed. I will move that we grant the hearing requests of Bennett's Camping Center and RV Ranch, Walter Shaw and Victoria Calder, Deborah and Peter Cook, Doris and John Faber, Woody Frossard, Judith Gagliardo, Cynthia and Norman Gookins, George and Cynthia Griffin, Ronnie and Diane Hasty, Kay and Bud Loack, John and Susan Metch, David and Kathy Montgomery, Keith and Colleen Nielsen, Jason Nolte, Stacy and Jim Rist, and Paul Williams, that we deny all remaining hearing requests and requests for reconsideration, that we refer the application to SOA for a contested case hearing on the following issues. Issue A, whether the draft permit complies with applicable requirements to abate and control nuisance odors as set forth in 30 Texas Administrative Code, Section 309.13E. Issue B, whether the draft permit is protective of water quality. Issue C, whether the draft permit is protective of groundwater and wells. Issue D, whether the draft permit is protective of the health of the requesters and their families, livestock, and wildlife, including endangered species. Issue E, whether the proposed discharge will adversely impact recreational activities. Issue F, whether the application is accurate and complete. Issue G, whether the modeling complies with applicable regulations to ensure the draft permit is protective of water quality. Issue H, whether the ED's anti-degradation review was accurate, and I'll specify that's the executive director's anti-degradation review. Issue I, whether the nutrient limits in the draft permit comply with applicable Texas surface water quality standards. Issue J, whether the commission should deny or alter the terms and conditions of the draft permit based on the consideration of need under Texas Water Code, section 26.0282. Issue K, whether the applicant's compliance history or technical capabilities raise any issues regarding the applicant's ability to comply with the material terms of the permit that warrant denying or altering the terms of the draft permit. Issue L, whether the proposed location for the facility complies with the 100-year floodplain and wetland location standards found in 30 Texas Administrative Code, section 309.13A and B. And finally, issue M, whether applicant substantially complied with applicable public notice requirements. And lastly, I would move that we set a hearing duration of 180 days from the date of the preliminary hearing until the proposal for decision is issued.
All right, I appreciate that. You hit all the issues that I was going to identify. I didn't have in my notes.
Did you want a second?
Yeah, I'll go ahead and second that now, and we can we can continue discussing it. But I did not have in my notes all of the citations to the water code and the administrative code that you mentioned. So I'm going to ask Ms. Smith if she was able to track those and if he read them correctly, I guess.
I tracked them and didn't hear any problems.
Okay, I appreciate that. I'm just, don't have that information, so appreciate that. And I think that covers everything for me. I don't think I have any other questions or comments. Anything else?
Obviously, a very, very thorough request and something that will offer a lot of issues to the SOA judge to discuss, get into. Yeah.
Absolutely. All right. Hearing no further discussion, the motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, please call the next item.
Item number 3 is the consideration of the appeal filed by Reeves County Appraisal District regarding a positive use determination issued by the Executive Director on Prop 2 application number 23712 to Rattler Midstream Operating LLC. The Office of General Counsel recommends 5 minutes per party for oral argument and the following order for oral presentations. Appellant, Reeves County Appraisal District, if present. Applicant, Rattler Midstream Operating LLC, if present. The ED, and then OPIC. The appellant may save some time for rebuttal as it bears the burden of proof.
Ms. Smith, has someone from Reeves County Appraisal District signed in to speak?
Let me check on that.
Or let me ask if maybe they're on the line. Is there anybody joining us virtually to represent Reeves County Appraisal District?
Chairman, no one registered from Reeves County.
All right, thank you for that. Moving on, is there someone with Rattler Midstream? Good morning, sir. Yes, sir. Are you Mr. Sanchez? Yes, sir. Yeah, why don't you come up to the podium? Go ahead and I think you might need to press the button on the microphone where it says push so the light comes on, and then I'll let you identify yourself and go ahead and make your comments.
So there's a green light on.
I hear you loud and clear.
Okay, good.
Good morning.
Good morning. My name's Ricardo Sanchez. I'm a property tax director for Merit Advisors and a Texas licensed property tax consultant for both Rattler Midstream Operating and Diamondback EMP LLC. I oversaw approximately 160 Tier 1 pollution control applications granted by the TCEQ with less than or approximately less than 5 applications being rejected and withdrawn based upon during the process based upon technical technical information. So when we discussed them with staff, there was a hurdle that could not be overcome, so those were withdrawn. Our staff worked closely with the professional staff of the TCEQ during the application process, providing technical information as required, confirming disclosures with our clients to ensure compliance with the program. Merit Advisors is here today to stand behind our collaborative work with the TCEQ. Merit Advisors agrees with the conclusion of the Executive Director's legal analysis and response and requests that you deny the appeals and affirm the TCEQ staff and Executive Director's positive use determination. Thank you.
Thank you, Mr. Sanchez. Commissioner Janeka, any questions for Mr. Sanchez?
I don't. I appreciate you coming here to be available, and I think the burden of this item really doesn't fall to y'all at this point. You've done your homework and really crossed your T's, dotted your I's, and I appreciate your appearing before us today. Thank you.
Thank you, sir.
Thank you, Mr. Sanchez. We'll hear next from the Executive Director.
Good morning, Commissioners. On behalf of the Executive Director, I am Sierra Redding with the Environmental Law Division. With me is Heidi Maldonado of the Air Quality Division. The Executive Director recommends that the Commission deny the appeal and affirm the Executive Director's use determination. Executive Director staff reviewed the Rattler Midstream operating application for the closed-loop piping system and determined that the equipment is used wholly for the control of pollution to meet a state regulation and is eligible for a 100% positive use determination. We have reviewed the Appraisal District's appeal. The Appraisal District did not file a reply. We continue to recommend that you affirm the use determination. Thank you, and we are available for any questions.
Thank you, Ms. Redding. I have none. Commissioner Janeka, any questions?
No, thank you.
Let's hear from the Office of Public Interest Counsel. Good morning.
Good morning, Chairman. Can you hear me?
Loud and clear. Thank you.
All right. For the record, this is Garrett Arthur, and good morning again, Chairman and Commissioners. OPIC respectfully recommends the Commission deny the appeal and affirm the ED's use determination. The Reeves County Appraisal District appealed the finding that property in application 23712 should be exempt from property tax and attached Rattler's May 2021 investor presentation. If a property item is included in the Tier 1 table, then the Commission has already determined that the item is used wholly for pollution control purposes, assuming it is used as described in the table and no marketable product arises from using the property. The present record does not indicate that a marketable product arises from use of the property or that the property is not used as described in the table. Further, appellant did not explain the basis for the appeal as required by 30 TAC section 17.25b and provided no explanation of Rattler's investor presentation and how it relates to the appeal. Without a more complete appeal, OPIC was unable to further evaluate appellant's submittal. For these reasons, the appeal is insufficient to overcome the finding which the Commission necessarily made prior to placing this property type on the Tier 1 table. Because the Tier 1 table includes the relevant Rattler property, OPIC must concur with the ED's positive use determination. Thank you.
Thank you, Mr. Arthur. Commissioner Janeka, any questions?
None. Thank you, OPIC, for the presentation.
Yeah, well, I think I'll repeat for the third time what we heard from the ED and from OPIC, but in different terms. This falls squarely within description S16 of the Tier 1 table. The appraisal district has not met its burden, so I think I'm ready for a motion on this if you're ready.
I'm always open to arguments from appraisal districts where we may be erring on the wrong side here. This is the easiest call. We've called Tier 1s the easy ones. You always get credit. I move that we deny Reeves County Appraisal District's appeal and affirm the Executive Director's positive use determination on application number 23712 issued to Rattler Midstream Operating, LLC.
The motion has been made. I second it. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, please call item 4.
Item number 4 is the consideration of the appeal filed by Reeves County Appraisal District regarding a positive use determination issued by the Executive Director On Prop 2, application number 23720 to Diamondback E&P LLC. Again, OGC recommends 5 minutes per party for oral argument and the following order for oral presentations. Appellant, Reeves County, applicant, Diamondback, the ED, and then OPIC. The appellant may save time for rebuttal as it bears the burden of proof.
Thank you, Ms. Smith, and I'll check once again just in case the appellant has been able to join us. Is there anyone for the Reeves County Appraisal District on the line? Hearing none, and I know they haven't signed in. Mr. Sanchez, I'll let you add anything you'd like to add with respect to Diamondback E&P, since we're on to that one now.
Thank you, sir. Thank you, sir. Just a repeat of what I had previously read. That should be sufficient.
I think so. Thank you, sir. I appreciate it.
Thank you.
Let's hear again from the Executive Director.
Good morning again, Commissioners. On behalf of the Executive Director, I'm Sierra Redding with the Environmental Law Division. With me is Heidi Maldonado of the Air Quality Division. The Executive Director recommends that the Commission deny the appeal and affirm the Executive Director's use determination. Executive Director staff reviewed the Diamondback E&P application for the closed-loop piping system and determined that the equipment is used wholly for the control of pollution to meet a state regulation and is eligible for a 100% positive use determination. We have reviewed the appraisal district's appeal. The appraisal district did not file a reply. We continue to recommend that you affirm the use determination. Thank you, and we are available for questions.
Thank you again, Ms. Redding. Commissioner Janecka, any questions?
I have none, thanks.
Mr. Arthur, what are your thoughts?
Good morning again, Chairman and Commissioners. This is Garrett Arthur for OPIC. OPIC respectfully recommends the Commission deny the Reeves County Appraisal District's appeal and affirm the ED's use determination. Appellant asserts that discrepancies of ownership exist between the TCQ documents and the appraisal roll. Financial documents from Diamondback prove the property is commercial property, and Diamondback is receiving fluids from other entities or companies. However, appellant failed to explain the basis of these assertions, and without a more complete appeal, OPIC was unable to further evaluate appellant's assertions. If a property item is included in the Tier 1 table, then the Commission has already determined that the item is used wholly for pollution control purposes, assuming it's used as described in the table and no marketable product arises from using the property. The present record does not indicate that a marketable product arises from use of the property or that the property is not used as described in the table. Therefore, the appeal is insufficient to overcome the finding which the Commission necessarily made prior to placing this property type on the Tier 1 table. Because the Tier 1 table includes the relevant Diamondback property, OPIC must concur with the ED's positive use determination. Thank you.
Thank you again, Mr. Arthur. I see it the same way. Commissioner Janecka, I think the appellant just hasn't met their burden here.
Agreed. And I will therefore move that we deny Reeves County Appraisal District's appeal and affirm the Executive Director's positive use determination on application number 23720 issued to Diamondback E&P LLC.
The motion has been made. I second it. All those in favor say aye. Aye. The motion carries. Ms. Smith, please call the next items.
That takes us to our enforcement docket, items 5 through 35. The Executive Director's staff is here to present these matters.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Melissa Cordell of the Enforcement Division, and with me today are Susan Jablonski, also of the Enforcement Division, and Charmaine Backins of the Litigation Division, representing the Executive Director. Pending before you are items 5 through 35. The total assessed administrative penalties are $328,380, with $51,942 deferred, $52,678 applied towards supplemental environmental projects, and $223,760 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you, Ms. Cordell. I have none. Commissioner Janecka, any questions?
I had one question on one item that I wanted to try to dig in a little bit more in depth on, Ms. Cordell, if I could. On item number 27, the agreed order here, and I appreciate and I respect the presence of this item on the agreed docket rather than a default docket. I think that puts me in immediately in a supportive mindset in terms of the executive director's competency in helping carry this across the finish line to getting a fully compliant order here. I'm just noticing the presence of a very similar description of the ground storage tank in the compliance history of the description of this item in the backup. And so I wonder if you might be able to give a little explanation on the status of that previous order that was mentioned in the compliance history. I have to confess when there's a variety of sticks and bolts used to describe the quality of plugs applied to a groundwater storage tank, and that language gets repeated, I'm immediately intensely discomfortable. So if you could provide a little more description of that and speak to where y'all are in your confidence of this site coming quickly into compliance.
Commissioner Janeka, this is Charmaine Backens with the Litigation Division. I don't know the answer to your question. I believe you're asking whether the ground storage tank at issue in the current enforcement action is the same as the ground storage tank that was at issue for the previous docket number. Is that correct? Am I understanding you correctly?
Yes, ma'am. Thank you for more clearly restating, I think, what the operative question is here.
Yes, and I'm sorry, I do not know the answer to your question, but I wonder if maybe my enforcement division colleagues might have some insight into that. So I'd ask Melissa Cordell or Susan Jablonski if they perhaps know the answer to your question.
Good morning. This is Melissa Cordell. And this order addresses that violation. So they were not in compliance prior, and so that's why it was included in this case.
Thank you for
yes,
confirming.
I apologize, Commissioner Janeka. It is a violation of the previous agreed order, the 2016-0197 PWSE. I'm sorry I didn't see that sooner. So it is the same tank.
I appreciate that, and thank you for confirming that. I think that the moving forward today is going to get us most swiftly to putting them on an immediate deadline to have that issue addressed or plans to do so sent back to our agency. If I understand the draft language in the draft agreed order for this one, so I'm happy to hear that will put this on a path towards compliance quickly. But I certainly encourage y'all to consider all the tools if it doesn't seem that we're getting resolution after, as it appears, unfortunately occurred back following the 2016 action we took.
Commissioner Janeka, thanks for asking the question, and Ms. Cordell and Ms. Backens, thank you for providing a little bit additional information. I had flagged that one also, as well as number 29. I'm concerned about the respondents on both of those items that they're just that we're not getting through to them, and but I think we're probably in better place, as you suggested, going forward with these orders. And then I would just ask staff to monitor closely and consider that if we're not getting through to them for future violations, that we not hesitate to refer those to the Attorney General's office. Because if we can't make sure that these regulated entities are ensuring safe drinking water as an administrative agency, maybe they'll take an action by the Attorney General's office a little bit more seriously. So that is that's not something I would put into an enforcement order. That's just some suggestion and recommendations from the dais. But I think I'm saying this the same way that you are.
Well said. I'm in agreement.
All right. Well, thank you, Commissioner, and thank you again, Ms. Cordell. Any other questions for Ms. Cordell?
Not, thanks.
Okay. Let's hear from anybody who signed in to speak. Do we have anybody who signed in to speak on any of these items?
No one has signed in on the enforcement docket.
Okay. That takes us to the Office of Public Interest Counsel.
Good morning. Vic McWhorter here, Public Interest Counsel. Chairman, I was glad to hear you mention item 29, and I wholeheartedly agree with your comments about that. I mean, I recommend approval of all the orders, including item 29. It did catch my attention, given that it appears the name of it, Little Lions Learning Academy, seems to imply they work with children there, and the nature of the violations. I know they have 60 days to update their chemical and microbiological monitoring plan, and I'm hopeful that the agency will monitor compliance with that very quickly and take appropriate action as needed, depending on what happens then. So thank you for making those comments, and I support issuance of the proposed orders.
Thank you, Mr. McWhorter. Any questions or comments, Commissioner Janetka?
No, I appreciate the substantive comments today. Thank you, Mr. McWhorter. Appreciate it.
I think we're ready for a motion.
I move that we adopt items 5 through 35 as recommended today by the Executive Director.
The motion has been made. I second it. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, please call the next item.
Item number 36 is consideration of the monthly enforcement report. The Executive Director's staff is here to present.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. My name is Melissa Cordell of the Enforcement Division, and with me are Susan Jablonski of the Enforcement Division and Charmaine Backens of the Litigation Division. We are here to present the monthly enforcement report for fiscal year 2021 through July. There were 858 effective administrative orders issued, and of those, 121 contain supplemental environmental projects. These orders assessed a total of $9,873,417 in penalties, with a payable amount of $6,241,308. $2,086,098 are to be paid towards supplemental environmental projects. 13,765 notices of violation have been issued through either our field offices or review of self-reported data in our central office, and 1,775 enforcement action referrals have been received. There are 1,806 pending administrative orders with 267 cases that are on the backlog. 199 cases are pending at the Attorney General's office for representation in district court, and 19 judgments have been issued. 2,023 cases are being tracked for compliance. We have included for review a summary of OCE investigative activities for fiscal years 2019, 20, and 21. We are available to answer any questions you may have.
Thank you, Ms. Cordell. I have none. Commissioner Janetka, any questions?
I appreciate the presentation, Ms. Cordell, and I think I'm holding judgment until the next time we see this report, when I believe the year for 2021 should reflect a complete year's worth of data. But it does appear to me that we are unfortunately a little higher on the number of backlogged orders than we were in previous years, and we're a little lower on the number of effective orders to date through 2021, significantly relative to both 2020 and also 2019, but 2020 was kind of a high year in number of effective orders. So I wonder if you might offer just a word of explanation. I suspect one factor could be that in the beginning of the new posture of the pandemic, where we're sent off, shut home, we staff did an excellent job in tackling all the low-hanging fruit and found all of those enforcement cases that lent themselves to it wasn't incompatible to dispense with them from a remote posture, and I suspect there may be other cases that got skipped over in that stretch, and what we would naturally expect to see, therefore, as that impeded or in any way altered posture over longer time may begin to reflect that, where the low-hanging fruit run out. So I just wonder, is there any element of that to what we see in the numbers in the report today?
Good afternoon. Good morning. Sorry, this is Melissa Cordell. Yes, your assessment is accurate. We did address all of the enforcement cases that we had available, and are endeavoring to continue to work through the cases that we have. And so we are working on our backlog cases as we move forward too, and we're looking into various ways to tackle those and to be more efficient in the future.
I appreciate that. And just case in point, I think that it's worth pointing out, and thank you, Ms. Cordell, and your colleagues across the Office of Compliance Enforcement for and all of the ED staff continue to participate in this new format that we're trying to have a hybrid meeting. I think it's difficult for multiple staff sitting on the other end of a phone line, getting asked a charged question that abruptly ends, and then not knowing which of the two or three of y'all may chime in. So thank you for the, I think, a helpful and informative answer, and for doing it in what I recognize as a tricky posture. Thanks.
All right. I think that, thank you, Commissioner Janeka. I think that takes care of it for the ED so far. Ms. Smith, has anybody signed in to speak on this item?
No one is signed in.
Thank you. And Mr. McWhorter, what are your thoughts?
I don't have any questions. I appreciate the report.
Thank you, Mr. McWhorter. Likewise, thank you for the report. No action is necessary on this item. So, Ms. Smith, I'll ask you to please call item 37.
Item 37 is the consideration of a resolution to appoint 8 nominees as members, appoint a current member as chairman, and extend the existence of the Municipal Solid Waste Management and Resource Recovery Advisory Council. The Executive Director's staff is here to present the item.
Good morning.
Good morning, Mr. Chairman, Commissioner, General Counsel, and the Public Interest Council. My name is Anju Chalis of the West Permits Division. With me today is Kayla Murray from the Environmental Law Division. We're here requesting the appointment of 8 new members to the Municipal Solid Waste Management and Resource Recovery Advisory Council. We also request the appointment of a president to the Advisory Council. Lastly, the most recent Commissioner's resolution for the Advisory Council was through 2013. We request to continue the Advisory Council until the end of most recently appointed member's term, August 2027. This Advisory Council is composed of 18 members who review municipal solid waste management policies and make recommendations to the Executive Director and Commission. The request for nomination was published in Texas Register on April 16. Nominations were closed on June 15. A total of 20 applications were received for 9 out of 10 specific qualifying positions. Staff reviewed the application received to ensure appointees meet statutory requirements for the selected position. In your materials, you have a listing of the vacant positions and biographical information of the recommended applicants. Thank you for your consideration of this matter, and we're available to answer any question at this time.
Thank you, Ms. Jalise. I have no questions. Commissioner Janeka, any questions?
None for me. Thank you.
Ms. Smith, has anyone signed in to speak on this item?
No one is signed in.
Thank you. And Mr. McWhorter, what are your thoughts?
OPIC recommends approval of the resolution appointing 8 members to serve on the Municipal Solid Waste Management and Resource Recovery Advisory Committee and appointing the new council president as presented by the Executive Director.
Thank you. I want to begin by thanking all of the nominees for their willingness to serve, and also the members for giving their time and talent in support of the really important work that this council does. I have no objection to the recommendation. It looks solid to me. So I think I'm ready for your thoughts or a motion.
I'm in agreement and appreciate you making that that recognition. Thank you, and thank you for all the public servants who have served on this this advisory council in the past, and are those who are stepping up to the plate. Thank you. Congratulations and condolences. Public service is a noble calling. I move that we adopt the Executive Director's revised resolution extending the existence of the Municipal Solid Waste Management and Resource Recovery Advisory Council until August 31st, 2027, and filling the vacancies on the Municipal Solid Waste Management and Resource Recovery Advisory Council as follows. Tennell Atkins as an elected official from a municipality with a population of 750,000 or more to expire on August 31st, 2023. Richard Abramowitz as a representative for the general public who would not otherwise qualify as members to expire on August 31st, 2025. Steve Shannon as a representative from a private environmental conservation organization to expire on August 31st, 2027. Frank Pugsley, P.E., as a professional engineer from a private engineering firm with experience in the design and management of solid waste facilities to expire on August 31st, 2027. Jennifer Lutz as a registered waste tire processor to expire on August 31st, 2027. Cheryl Murgo as a representative from a planning organization to expire on August 31st, 2027. Charles A. Rivet as a solid waste professional with experience managing or operating a commercial solid waste landfill to expire on August 31st, 2027. And finally, Tom Yardley as an elected official from a county with a population of less than 150,000 to expire on August 31st, 2027. And I move that we adopt current advisory council member David Yank as advisory council president to expire August 31st, 2023.
I noticed when you were talking about Ms. Murgo as a representative, you said as a representative from a planning organization. Did you mean region?
Thank you for yes, I did mean Cheryl Murgo as a representative from a planning region to expire on August 31st, 2027 in that motion.
Thank you for that
Appreciate it.
clarification.
We can consider that a friendly amendment or clarification. I'm not going to make you reread that
Thanks.
motion. Sounds good to me. I'll second it. The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, please call the next item.
Item 38 is the consideration for adoption of the amendments to air quality standard permit for concrete batch plants. The executive director's staff is here to present the item.
And good morning. Before you get started, I think that I think we're ready to get started. So let's hear from ED staff.
Good morning, Chairman, Commissioner, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I'm David Munzenmeyer with the Air Permits Division. With me is Amy Browning with the Environmental Law Division. For your consideration today is the adoption of the updated air quality standard permit for concrete batch plants authorized under Texas Health and Safety Code Section 382-05195 and Title 30 Texas Administrative Code Chapter 116, Subchapter F. This update to the standard permit will reinstate an exemption from emissions and distance limitations in 30 Texas Administrative Code Section 116-610A1. The exemption was inadvertently removed during a previous amendment. In addition, minor word usage changes have been made to subsections 3E and 3FI to clarify when owners or operators must comply with the most recent revision to the concrete batch plant standard permit. Notice of the proposal was published in the May 28, 2021 issue of the Texas Register, 46 Tex Reg 3440. A public meeting was held on June 28, 2021. The public comment period ended at midnight, June 29, 2021. The rule team did receive public comments. However, staff determined that no substantive changes were required based on those comments. Additionally, staff requests authorization to make non-substantive revisions necessary to comply with Texas Register requirements. In conclusion, staff respectfully recommends adoption of this standard permit. Thank you, and we are available to answer any questions.
Thank you, Mr. Munzenmeyer. I have none. Commissioner Janeka, any questions?
I don't. No, thank you. Appreciate it.
Thank you. And I understand that we may have several people signed in to speak on this item. I'd like to begin with Representative Cook, if he's on the line, or a staff member. Is someone there for Mr. Cook's office? And let me give you just a moment to double check your mute button. All right, well, tell you what, why don't we, if Representative Cook or a staff member is able to join us, we will work them in, but why don't we go ahead and hear from other folks who have signed in to speak.
Mark Friesenhahn.
Good morning, Mr. Friesenhahn.
Yeah, good morning.
Good to see you, sir. I'll ask you is the light on that microphone in front of you?
The green light is indeed on.
Great. I can hear you loud and clear. Why don't you go ahead and identify yourself for the record, and then go ahead and make your comments, sir.
Good. Yeah, good morning, Chairman, General Counsel, and the Commissioner. My name is Mark Friesenhahn. I'm commenting as a private individual and as a member of a statewide coalition called TRAM, Texas for Responsible Aggregate Mining. And I might add, I'm also an affected party with a large concentration of APOs that have literally surrounded my farm. And I've participated in hearings on concrete batch plants in that group and experienced a fine tailing spill from the adjacent quarry. So I'm pretty intimate with the whole issue.
You're a student of this issue, maybe a professor of this issue, it sounds
Well,
like.
I'm not a professor. I'm still in the apprentice stage, but learning. We disagree with the proposal, the proposed amendment in this item. Basically, it would exempt consideration of the silica in the sand used to make the cement in standard batch, concrete batch plants. We recommend that you vote no today and leave the 2012 set of rules on standard concrete batch plants as is. You, the commissioners, got it right when earlier in the year you voted to disapprove a Tarrant County concrete batch plant permit application because the applicant did not account for the silica in the sand being used in their cement process. Subsequently, despite, and I'll read some words here that add character, despite some objections to the TCEQs, what we feel like was a fairly opaque public communication strategy on the changes, and as well as the brevity of the comment period. And you notice those dates mentioned by the executive director's staff are pretty close together. We felt that was way too short for an unexpected and technically complex permit revision. Despite that, and despite the fact that we had over 20 senators and representatives comment, asking for an extension, and over 1,400 individuals and groups also commenting, asking for an extension, the staff and the executive director disapproved the request for extending this so it could be studied further. We feel like the action's unfair and unreasonable. The amendment is being characterized as a simple administrative change. We disagree with that. To the contrary, there have been something like, and I'll use the number 800, I've heard 700, I've heard 812, let's say round numbers, 800 standard concrete batch plants that have been approved, permits for which have been approved by the TCEQ since 2012. In almost all cases, it could be argued that those permits are in violation of the rules since silica and sand was not considered in the permit application on almost all of them.
That's time.
Go ahead and finish your comments, sir.
Okay. The letter sent in outlined our comments in detail. Just a couple of points. We feel like the standard permit approach and the regional monitoring does not reflect the air quality and particulate levels near these concentrations of APOs. The cumulative effect is not being considered. And because of that, I don't think anybody really knows what the air quality is in these concentrations of concrete batch plants, and there are a lot of them in the state, and they are concentrated. I'll give an example. When is the last time the staff has presented data on air particulate emissions in a graphical form to you guys? We don't see it. We think the mission statement needs to be balanced for commercial development and public health. It's swung too far to the commercial development side. I'll mention one more point here that's, I think, relevant. The APO and their support organizations are quick to say, yes, approve it if it's a rule change favoring less interference in their business. They're even quicker to approve a rule change or to object to a rule change where it balances the equity between all the stakeholders involved. And in fact, they do this while they leave out the inconvenient truths such as the fact that we don't really need all of the new permits to meet the demand for products. They're doing a good job. They're meeting demand for our growth in Texas, but we see the industry as running at a less than 1 ratio of demand divided by supply capacity. We're asking that you continue your decision where you rejected the Tarrant County application and vote no to the amendment. Be happy to answer any questions. We have a lot of data. I left all the numbers and the references to the codes out, but that's the essence of our story. Thank you very much.
Thank you, sir. I have no questions. Commissioner Janeka, any questions?
Thank you for your time.
Thank you.
Thank you for being here. Ms. Smith, who's next?
We have Matt Posey representing Representative Cook on the line.
Good morning, Mr. Posey. Can you hear me?
Good morning. Can you hear me?
Loud and clear. Go ahead when you're ready, sir.
Absolutely. I'm just submitting testimony on behalf of Representative Cook. I'll just head right into it. Thank you, Commissioners. My name is Representative David Cook. I represent myself and the citizens of House District 96, and I hereby submit this written testimony on Agenda Item 38, which proposes to amend the air quality standard permit for concrete batch plants. I've come before you multiple times this year to discuss the issues caused by concrete batch plants and their negative effect on communities that surround them. I am disappointed to see this amendment to the air quality permit proposed, as it aims to remove a safety measure that keeps Texans safe. In my community of Mansfield, I've joined with my neighbors to fight the approval of a CBP that failed permitting requirements due to not meeting the very rule that this commission is considering amending today. Though our efforts resulted in the first victory by Texans opposing the construction of a CBP in their neighborhood, this amendment appears to be a reaction to ensure that no future opponents to CBPs are allowed to prevail. If that's not the case, I would ask why the rule was allowed to remain unamended since 2012, only to be abruptly changed only after it became an obstacle to a company that proved to be irresponsible in their application process. The emissions limitations established to ensure the health and safety of the community should be a top priority when deciding whether to approve or deny concrete batch plant permits. In their proposed amendment proposal, TCEQ staff admitted that they did not explicitly model the levels of crystalline silica emitted by CBPs during their 2012 protectiveness review, and are relying only on estimates of what those levels might be in determining the health-based effects screen's level. The health of Texans should not be placed at risk based upon what the assumption of what the emission levels might be, and therefore I ask that at the very least the Commission specifically examine the levels of crystalline silica emitted by CBPs before adopting an amendment that removes protections from such emissions. Commissioners, I thank you for your time and for what you do for Texans. Thank you so much.
Thank you, Mr. Posey. Appreciate that. Commissioner Janek, any questions or comments?
I only point out, Mr. Posey, I've been in your seat before in terms of the position relative to the elected official, working relative to the House District, and I appreciate you taking the time to call in and read the representative's remarks.
Thank you so much.
My only question to gently prod is please take the message on to the rest of the legislature to give us explicit directions to do exactly what your boss is calling on us to do. I'm not sure that I see a clear path for us to do that without falling into deeper trouble in the eyes of the legislature in terms of our consistent posture across all Texas industry in the state. But thank you again for taking the time to read that for us.
Absolutely. Thank you for having me.
Thank you, Mr. Posey. Thank you, Commissioner Janeka. Ms. Smith, who's next?
Christian Menifee.
Thank you very much, Commissioners, for allowing me to speak today. My name is Christian Menifee. I'm the county attorney for Harris County, Texas, the largest county in our great state. And I'm here speaking today because our county will likely be impacted more than just about any other county in the state by these rule changes. There are about 130 concrete batching plants in Harris County. And as I'm sure you all know, we have many communities that are disproportionately impacted. If you take Fifth Ward, for example, the disproportionately African-American community has 4 concrete batching plants. And of course, you can compare that with River Oaks or other affluent white areas in our county, which have exactly 0. There are several concrete batch plants in eastern Harris County in predominantly low-income Latino neighborhoods. Now, we have, and I'm moving quickly because I know I have 3 minutes, we've submitted a comment letter that details all of our recommendations. So I saw one of the commissioners ask the last speaker for that. We've already submitted that. And I'm basically here to re-urge those recommendations and ask that you review that letter in detail. One major issue that we pointed out is, we'd like you to extend the public outreach and notice processes for the standard permit to provide notice in communications in Spanish. 20% of residents in Harris County are less than proficient in the English language. And of course, that's disproportionately in certain neighborhoods. We have one neighborhood, which is less than a couple of miles from several facilities, that has just under a majority of residents who only have a limited proficiency in reading and speaking the English language. And for these folks to really be made aware of the facilities that are seeking permits in their neighborhood, you're going to have to provide notice in Spanish. We have here in Harris County in recent years substantially increased our investment in pollution control, and we have a pollution control department. And since February 2020, they've conducted 122 investigations of concrete facilities, and they've issued 144 violation notices. And it's for all the stuff that you'd expect. What we most often see are violations of the standard permit. So this is unpaved entry and exit areas, failure to immediately clean up spilled materials, failure to meet buck distance requirements, and so on. But given these issues, I just want to re-urge all of the recommendations that are in the comment letter that we submitted. a few examples is, we'd like these facilities to install a 12-foot high dust suppressing barrier as a border around roads, traffic areas, and work areas. We'd like for these facilities to keep stationary equipment, stockpiles, and vehicles used at the plant located or operated more than 100 feet from any property line. We'd like for stockpiles to be covered for when not in use to minimize dust. We invest a lot in Harris County in taking enforcement action or taking pre-enforcement compliance measures with these facilities. And we think that there's more room for growth of the standard permit to ensure that these facilities are doing what they need to do up front. And one of our major recommendations is that these folks have to get an as-built certification that's signed and sealed by an engineer and submit that to the TCEQ. But again, thank you for taking the time to listen to me. It's incredibly important to us in Harris County, and I hope that you all will consider our recommendations and incorporate them into the standard permit.
Thank you, Mr. Menifee. Appreciate your comments. Commissioner Janek, any questions or comments?
No, thank you for the input today.
Thank you. Ms. Smith, who's next?
Amy Din.
Good morning, Ms. Din.
Good morning. This is Amy Din with Lone Star Legal Aid's Environmental Justice Team on behalf of our client Super Neighborhood 48, which is Trinity Gardens, Houston Gardens of Houston, Texas. Well, our comments here expound on written comments as well as oral comments that we made at the public meeting that the TCEQ hosted on this permit amendment. First, the TCEQ did not extend that comment period despite requests by multiple legislators and commoners. And the comments reflect concerns about changes being made to this permit that do not comply with the law. The entire permit relies on a protectiveness review that was not made available to the public with notice. There are admissions in response 6 in the agenda item request that the protectiveness review from 2000 on which the exemption is based did not include a protectiveness review of crystalline silica. And this permit claims to be making no substantive changes. But that statement is only true if the TCEQ's statements about the protectiveness review are correct. Since this information was not available for public comment, the TCEQ's conclusory statements without further support need to be questioned. Commissioner Lindley encouraged commoners to submit all comments on the standard permit for this agency's review. Commoners like Super Neighborhood 48 and Harris County, who just heard from, took the opportunity to provide feedback on operational methods that could be adopted to ensure protectiveness, to correct issues that are seen in regular violations at these facilities. These suggestions were not incorporated or considered. Despite soliciting feedback on the permit generally, at the public meeting, the agency announced that the proposed amendment was limited in scope to this exemption. However, in the agenda item request, the TCEQ acknowledges making other changes to the permit that were beyond what was publicly noticed. That is, word usage changes to certain subsections in the permit. These changes were not included in the public notice of the proposed amendment. Further, the notice did not contain information included in the agenda item request. Specifically, the TCEQ did not provide any information on the protectiveness review, despite being specifically requested by commenters. There was no opportunity to review or respond to the statements that are now made after the fact to support the TCEQ's actions. Further, the TCEQ did not provide notice in Spanish. A large percentage of the population in Texas speaks Spanish as a primary language, and a disproportionate number of the people who live near proposed or existing concrete batch plants speak Spanish. The limited English proficiency issues presented by the deficient notice are of concern because the agency recently undertook a review of its programs to increase language access requirements. The agency needs to be consistent in its approach to public participation and not pick and choose which issues it wants to make accessible to those who speak other languages, particularly given the long-term impact on these environmental justice communities. Finally, the TCEQ's response acknowledges that exposure to PM 2.5 can have severe health impacts. TCEQ further concurs
Go ahead and finish up, Ms. Din.
The TCEQ further concurs that the standard permit must comply with NAAQS for particulate matter. However, the protectiveness review and monitoring data that the TCEQ references and relies on to support its decision that the standard permit is protected and complies with NAAQS are not provided for public review or comment. In summary, Super Neighborhood 48 is concerned about the abridgment of public participation rights in connection with this permit amendment and the TCEQ's process. Thank you for listening.
Thank you, Ms. Den. Appreciate your comments. Commissioner Janeka, any questions or comments?
None. Thank you for the comments.
Ms. Smith, who's next?
Carolyn Crow.
Ms. Crow, are you there?
I am. Can you hear me?
I can. Good morning. Go ahead when you're ready.
Good morning. My name is Caroline Crow. I'm a staff attorney with Lone Star Legal Aid on the environmental justice team here on behalf of Super Neighborhood 48. The concrete batch plant standard permit deficiencies implicate environmental justice concerns across Houston, and the standard permit does not comply with the TCEQ's environmental equity policy. I'd like to highlight specifically some concerns and connect them to the response to comments and their deficiencies in Super Neighborhood 48, and echo what Amy Den said, that we already submitted written comments and gave oral comments on a lot of this. So Super Neighborhood 48 is just one example of communities that are affected by concrete batch plant standard permitting and the deficient practices. For example, this community has 8 concrete batch plants and other co-located aggregate storage facilities, all within less than 7 square miles. In addition to this, the community is bordered by several rail yards, but the standard permit doesn't account for other off-site sources when approving any particular standard permit application, and the ED, our response to comments states that there are no adverse impacts are expected as a result of multiple similar facilities co-located, but there's no basis provided for this determination. That's at the response to comments pages 8 to 9. The response to comments admits that few data measuring around particulate matter in conjunction with concrete batch plants has ever been conducted. That's the response to comments at page 10. So what are the results of this? Well, an entire community has documented concentrations of poor air quality and subsequent health impacts that result from this defective permit that's not sufficiently protective. The ED's response to comments states several times over that no adverse impacts are expected from the operation of multiple similar facilities in the same community. And that was objectively rebutted by air emissions data that we submitted in our public comments on behalf of Super Neighborhood 48. Further, the RTC, as several other commenters have suggested, admits that crystalline silica impacts were not even modeled at the RTC page 9. The RTC also admits that not everyone responds to air emission exposures the same. Children and elderly are more susceptible, and populations heavily impacted by COVID-19 would be more susceptible. And the standard permit doesn't account for these populations or these demographics or COVID-19 concentrations. So Super Neighborhood 48 is particularly susceptible also to flooding and other commingling of stormwater and processed water and insufficient detention ponds. So when this flooding occurs in Super Neighborhood 48, it creates serious problems. I see I'm almost out of time, so these are just some examples of issues with the standard permit and what the community deals with. We really appreciate your time and encourage the TCEQ to use their plenary authority to evaluate these concerns and respond accordingly. Thank you so much.
Thank you, Ms. Crow. I appreciate your comments. Commissioner Janeka, any questions or comments?
None. Thank you.
Ms. Smith, who's next?
Regina Broughton Smith.
Are you there, ma'am? Ms. Broughton Smith? Is Miss Broughton Smith?
Yes.
I hear you now.
Hello.
I hear you now. Good morning.
Good morning. My name for the record is Regina Broughton Smith, and I don't have too much more to add. I am strongly opposed to the adoption of that amendment to the air quality standards permit for the concrete batch plants, and they should not be exempt from the emissions and distance limitations. I have no more to add.
Thank you, ma'am. I appreciate you joining us this morning. I appreciate your comments.
Thank you.
Ms. Smith, who's next?
Stephanie McBodiga.
Good morning. Are you there?
I am. Are you able to hear me?
Loud and clear. Go ahead when you're ready.
Thank you. Good morning, and thank you so much. I appreciate the opportunity to comment. My name is Stephanie Badiga. I am the Legal and Advocacy Director for Airlines Houston. On behalf of Airlines Houston and the communities we serve, we do oppose the amendment for the standard permit concrete batch permit for multiple reasons. First, we do believe that TCEQ did not respond appropriately to the comments that were drafted and the oral comments presented on behalf of airlines and as well as other people. We do echo Lone Star Legal Aid as well as Harris County's issue. So first, there needs to be a comprehensive study on crystalline silica. These estimates are simply deficient because it just does not take into account many factors, and the estimates are supposed to be on conservative models, and it simply just does not work for these communities who are overburdened by multiple industrial facilities. The second issue is that TCEQ continues to make a blanket statement that it is protective of health, and it is simply not. So TCEQ does not take into account equity or environmental justice. It even acknowledges and admits that it simply has no policies on this, but then it further contradicts itself to say that it does maintain and try to implement environmental equity. So in order to do that, there has to be some form of meaningful involvement from the community. So as echoed and mentioned before, not having permit notices or any notices of the kind in other non-English languages does not serve environmental equity. It puts these communities who tend to be communities of colors and lower socioeconomic status at risk of not knowing what's going on. Second, I think that it's really important to note that TCEQ also admits that there are sensitive populations who are more at risk for inhaling different substances and air pollution. But in the same right, TCEQ does not respond to what it's doing to address that. TCEQ also admits that it does not take into consideration the populations that live in these areas where concrete batch plants are currently thriving. But in relation to that, all of the active concrete batch plants in certain zip codes, for example, 77020, are part of cancer clusters in Houston. And so in order for TCEQ to continue to propose these amendments without any other protective factors, it's actually damaging for these populations. It's showing almost a disregard for these communities. And I truly hope that we can urge TCEQ to complete a comprehensive silica study and to reach out to grassroots organizations, community-based research organizations to figure out a way that they can include environmental justice and environmental equity into its permitting process. Thank you so much.
Thank you, Ms. McDiva. Commissioner Janeka, any questions or comments?
I appreciate the comments. Thank you.
Ms. Smith, who's next?
Corey Williams.
Is Corey Williams with us? You might check your mute button. Corey Williams.
Chairman, he seems to be having an audio issue. I can give him a call and see if I can help him out.
Let's loop back to him. And who's next?
Erica Hubbard.
Ms. Hubbard, are you there? And Ms. Hubbard, you might check your mute button.
Hello?
I can hear you. It sounded faint. Let's try. Can you hear me?
Yes, I can hear you loud and clear.
Okay. If you'll speak up just a little bit, I think we'll be just fine. Good morning.
Okay. Good morning. Good morning. Thank you all so much for allowing me to address your commission. My name is Erica Hubbard, and I live in Super Neighborhood 55 in Houston, Texas. I'm in zip code 77020. And I'm here to address the fact that Texans all have the right to breathe clean air. And TCEQ's policy of not accounting for the crystalline silica creates a situation in my neighborhood where unlimited emissions are entering our atmosphere unchecked. We all know that crystalline silica is an EPA-designated lung irritant, and it could lead to lung cancer. Sir, all of the active concrete batch plants in my zip code, 77020, and the adjacent zip codes, 77026, 28, and 29, are all located in existing cancer clusters, according to research conducted by the City of Houston's Health and Human Services Department. Also, in these particular zip codes, they're all above average native air toxic cancer risk. And so because of these facts, TCEQ is proposing, what you all are proposing will exacerbate an already dire situation in my neighborhood, and particularly this neighborhood, which is consisting of people of color. So we strongly oppose your attempt to exempt the standard air permit from crystalline silica monitoring compliance. And we ask that you all create some sort of moratorium on issuing standard air permits until you're able to conduct proper scientific research from reputable institutions. Thank you.
Thank you, Ms. Hubbard. Appreciate your comments. Commissioner Janeka, any questions or comments?
Likewise, thank you for calling today.
Ms. Smith, who's next?
Alvin Bird.
Mr. Bird, are you with us?
Yes, I am. Thank you so much, Commissioner and General Counsel. My name is Alvin Bird, and I'm president of the Prince Square Civic Association that sits right in the middle of Harris County, Houston, Texas, 5th Ward, zip code 77020 and 77026. As you guys have heard this morning, these areas, these zip codes that we are speaking of this morning are sandwiched with existing concrete batch plants or ready-mix plants. And as a matter of fact, we have one proposed new concrete batch plant within 1,000 yards of the already existing batch plant. Commissioners, we had our Civic Club meeting last night, and as you heard County Attorney Christian Menifee mention, that in this 5th Ward area, we are very geriatric that live in this area, and also a lot of
Mr. Bird, I'm sorry. Let me interrupt you.
within
Just
this Prince Square.
Mr. Bird, I'm sorry to interrupt you. You cut out for just a second, and I missed what you said after in the 5th Ward. Do you mind backing up and picking up your comments there you were talking about in the 5th Ward?
Okay, can you hear me now?
I can. We just lost you for a minute, so hopefully the connection will stay with us.
Thank you so much, Commissioner. In the 5th Ward, which is zip code 20 and 26, 77020 and 77026, there are already 2 existing concrete batch plants or ready-mix plants right near. We have a daycare center, we have a park, we have senior citizens living on the fence line of these existing concrete operations. There is also one that's being proposed to open less than 1,000 yards from one of the already existing concrete batch plants. That would inundate our community with concrete batch plants, and you know, of course, those that go unregulated, unchecked, causes a great health concern in this Prince Square Civic Association area. Last night, Commissioner, we had a meeting with our Civic Association, and I must tell you, even though we go to great lengths to have interpreters for our Spanish-speaking residents, we found that there was not any Spanish, any notifications in Spanish for our people to participate in their public comments. Taking consideration that we already have one of these existing ready-mix plants that has been operating for 2 years without a permit. Now, we don't know all of the terminology, and we're lay people in regards to how this concrete batch plant operation works. However, we do understand the great health risk. So as a representative for the Prince Square Civic Association in the 5th Ward area, we strongly oppose any measure that would eliminate any type of monitoring of silica or any other agents that would cause unhealthy situations for our community. And thank you for hearing me, and we appreciate your consideration.
Thank you, Mr. Byrd. We appreciate your comments and appreciate you being with us today. Commissioner Janeka, any questions or comments?
None. Thank you for the comment.
Ms. Smith, who's next?
Janet Hurlbut.
Ms. Hurlbut, are you on the line?
They don't hear you, Jan. Jan, they don't hear you.
Ms. Hurlbut, you might check your mute button.
We heard you.
Can you hear me now?
I can. Thank you. Good morning. Go ahead when you're ready, ma'am. And we've lost you again, I fear. Ms. Hurlbut, are you there?
No, they don't hear you. This is second. Get that thing on or not? You messing with it? Stop.
Can you hear me?
I can hear you now.
Can you hear me now?
Can you hear me now?
Yes, ma'am. Why don't we give it a shot? If you'll identify yourself and let us know what's on your mind, and hopefully our connection will hold.
Okay, I'm Jan Holden.
And doggone it, you're fading out again.
Jan, you're fading out again.
Can you hear me now?
I can, but it seems to be intermittent. Why don't we try again? Go ahead. Ms. Hurlbut, this appears not to be working, and
Not working.
I'm not good at diagnosing these issues in the best of circumstances. So why don't we try coming back to you, and in the meantime, maybe you, perhaps with some help, can make another effort at getting a good connection to us. And Ms. Smith, let's take the next person at this time.
The next person I had on my list was Roger Hurlbut.
Mr. Hurlbut, are you there?
Yes, I am. Can you hear
Okay,
me?
and you're coming in loud and clear.
Well, good.
Go ahead and share your thoughts with us when you're ready.
Thank you. I'm Roger Hurlbut. I'm an organizer of the group that successfully challenged the Bosque Solutions Group. I'm an attorney. I'm also a resident just beyond the 440 margin for that batch plant. I'd like to address some things that have not been addressed so far. I hope I don't overlap. The TCEQ staff said the need for this rule change was because of an inadvertent mistake in 2012. They said there were no additional or new studies or analyses other than the protectiveness review done in 2012. That does not seem to be the case at all. Excuse me for catching my breath. I was running to the other part of the house to help my wife. So just give me a second.
Sure thing.
Thank you. The first thing I'll comment about is in its June notice, the TCEQ staff said that the exemption was inadvertently removed from the 2012 rule amendment. Yet, in the memo of just September 2nd of this year to support today's amendment, the staff provides zero evidence, testimony, or documents showing this was in fact a mistake, inadvertent or otherwise. There's not a single affidavit or person coming forward, none whatsoever. Now, neither the public nor the commissioners can or should just take the staff's word for it. This has to be a fact and evidence-based decision today, I assume. But the staff came up totally empty on that point. There is no evidence this was an error, inadvertent or otherwise. Staff keeps repeating it, but that repetition does not make it so. Secondly, as I recall, the TCEQ staff previously represented to these commissioners in the Bosque Solutions case that the silica emissions were considered or made part of the protectiveness review by the TCEQ. That should be a record. Yet in the September 2nd memo, it admits exactly the opposite. I'm trying to quote here if I can find it. Quote, the commission did not explicitly model the levels of crystalline silica emitted by a concrete batch plant in the 2012 protectiveness review for the standard permit. That's response 6, page 9, and response 8, page 11. This disingenuous to the public and to this body cannot be ignored. Number 3, at the June 28th public hearing that we had about this, during the Q&A portion at the very beginning of the hearing, the TCEQ staff specifically stated that only the 2012 protectiveness review was being relied upon for this new rule change. Nothing else, nothing new, nothing additional. There were some four specific questions to the staff made at that time. This is also a record. The staff's answer during Q&A, after much hesitation, I might add, by the staff on the record, was that there was no additional supporting materials, impact studies, or analysis reviewed or generated to be relied upon for this rule change. No impact review of silica, no new protectiveness review. There is nothing new or additional to support the amendment other than, again, a 2012 review.
That's time.
Go ahead and finish up, Mr. Hurlbut.
Yet, it's just the opposite. In its September 2nd memo, they have a brand new study where they said that he conducted a recent estimate that the levels of crystalline silica might be and were compared. This is a brand new after-the-fact study. It was never revealed to the public, never posted, and it's the opposite of what they said. I think the integrity and honesty of this review process has been opened. It shows a lack of openness. One other thing, it didn't respond to my 3-page letter I submitted to the comments on June 28th, where I discussed the overall problem of these reviews, where it's 800 to 1. 800 approved concrete batch plants been approved, and only one has been successfully challenged through the entire process, and that's the Bosque Solutions. I simply ask that this be postponed, the rule re-up for amendment change, or it be denied. This is not fair, and the staff has been cabining these studies and not allowing the public to review them or this process to be enabled to allow that to happen. Thank you.
Thank you, Mr. Hurlbut. I wonder if we can give you a minute to get your wife on the phone. Maybe she could use your phone instead of her phone so we can hear her clearly.
Fair enough. Just a moment.
Okay. Thank you, sir.
Okay, can you hear me now?
Yes, thank you. Go ahead, please.
I think he has a better phone than I do. Yes, I'm Jan Hurlbut. I live within a half mile of a formerly proposed concrete batch plant in Tarrant County, Fort Worth, ETJ 76063. And I'd like to make a few comments. The permitting process for standard permit concrete batch plants in Texas through TCEQ is broken. TCEQ has lost its mission if it continues to use and not update the currently formulated permit. In the time for transparency about the 2012 amendment, clerical error, and protectiveness review, as well as reexamination of the fairness and effectiveness of the standard permitting process. TCEQ's exemption eliminates any requirement for air modeling for proposed plant and relies upon the protectiveness review from well over a decade ago. TCEQ's failed to make available the protectiveness review as it used in 2012, or before 2012, including any specific risk analysis and scientific studies or reports concerning the dangers and risk of crystalline silica emissions, among several other pollutants. Based on my information, and contrary to representations from certain folks within TCEQ, there's never been any specific evaluation of emissions of crystalline silica in formulating the standard permit for concrete batch plants, other than the 2012 rule. If that is true, if TCEQ cannot produce any such study or report, then TCEQ cannot and should not proceed with proposed rule change to exempt limits on toxic crystalline silica emissions. TCEQ has withheld critical information from the public to allow meaningful and informed public comments concerning the instant proposed rule amendment to exempt limits on crystalline silica and other unnamed emissions. By design, the one-size-fits-all in this standard permit, it cares little about particular realities for a given site, neighborhood, weather patterns, or terrain. It's even more so in residential neighborhoods. In 2012, TCEQ had made numerous generic assumptions with abbreviated techniques to apply this permit across the entire state, the area larger than many countries. Among other things, TCEQ purposely shortened or streamlined its analysis by using data from Austin and Victoria from 1983 to 1988. It eliminated consideration of downwash structures and used techniques to eliminate more detailed modeling. This approach stripped away much environmental protection for individual residents who are confronted with a standard concrete batch plant in their neighborhood. Thus, simplicity of the permit form and case of agency administration appear to have been the goal rather than genuine mindfulness of it. Texas citizens living near a batch plant with a standard permit have much less assurance of protection than Texans living near a batch plant with more rigorous permits. This fails to provide equal protection for the health and property of all Texans, and compounding this is that many of these areas are neighborhoods of underprivileged and minorities, including Spanish-speaking individuals. This is an alarming statistic that some 800 approved permits went through with successful case which denied it. It's an alarming statistic, and is my time up?
No. Why don't you go ahead and finish up? The clock expired, okay. but please just go ahead and finish up.
Okay. This is an alarming statistic, and it invites distrust from the public that the TCEQ is primarily charged with to protect. The legal fees and costs to challenge a standard permit through contested case hearing and beyond is prohibitive for individual owners who are lucky enough to have standing for a contested case hearing by living within 440 yards of a proposed plant. These fees and costs easily exceed $130,000 to $200,000 or more. I know. The 3-year battle of the grassroots volunteers who were able to raise funds to successfully challenge the Bosque Solutions permit near Mansfield, Texas, is the case in point. It is the one rare, if not only exception. Most all, if not all other neighborhood groups cannot afford to organize, run out of funds, or they quit fighting the permit or capitulate by settling for minor concessions while the concrete batch plant permit still gets approved. This reality has shifted TCEQ's responsibility to protect the public onto the backs of the individual members of the public. Furthermore, standard permits, they are currently used in neighborhoods that are disadvantaged, including minorities and Spanish-speaking citizens. TCEQ, to my knowledge, has never issued anything in Spanish to address these individuals. So I request that this proposed rule amendment be withdrawn and renoticed with proper documentation showing why the exemption was inadvertently left off in 2012, and importantly, how crystalline silica and other previously unmentioned minerals and chemicals were specifically addressed in 2012, if at all, and why a new protectiveness review should not be part of this so-called update to the rules. Thank you for listening.
Thank you, Ms. Hurlbut. Appreciate your comments. Commissioner Janicka, any questions or comments?
Thank you for the comment today.
Ms. Smith, who's next?
Let's try Corey Williams again.
Mr. Williams, are you there?
Can you hear me this time?
Loud and clear. Good to hear you. Good morning, sir. Go ahead when you're ready.
Yeah, good morning, everybody. Thank you for the opportunity to speak. My name is Corey Williams. I am the Policy and Research Director for Air Alliance Houston. We are opposed to the adoption of this amendment as it stands today. We have submitted detailed comments on the crystalline silica protectiveness review and other issues related to this amendment that other commenters have already well addressed. But I'd like to use this opportunity to speak more generally about the issues surrounding concrete batch plants in Texas. As the Commission knows very well, there's a great deal of controversy and concern regarding the siting of concrete batch plants in the state of Texas. The public reaction to this rather arcane rule change on today's agenda, what the ED has characterized as the correcting of a simple clerical error, should serve to highlight those concerns. Hundreds of Texan residents and dozens of state legislators have chosen to use this opportunity to ask that the TCEQ make the standard permit more protective of public health and the quality of life of Texans. They have chosen to take advantage of this opportunity because they share deep concerns about the way this industry has been allowed to operate in the state of Texas, and they are frustrated because there seems to be little recourse to change the situation. Local ordinances and state legislative efforts have proven to be ineffective remedies to address the issue. Over 1,300 concrete batch plant permits have been issued throughout the state of Texas. So they are somewhat ubiquitous throughout the state. In cities without municipal zoning plans and in unincorporated county lands and ETJs, the TCEQ permit requirements, or lack thereof, play an outsized role in determining local land uses. In urban contexts like the city of Houston and greater Harris County, home to over 180 concrete batch plants, this results in concrete batch plants invariably being located in communities of color and low socioeconomic status. These are areas where property is devalued, residents have less political capital, and facility operators have easy access to metropolitan area construction projects. And we feel that this is clearly a textbook environmental justice issue that is going unaddressed. Too often these facilities come into conflict with pre-existing land uses. I've personally witnessed permitted facilities that share property lines with residences, facilities that are adjacent to public playgrounds, and that are within throwing distance of public schools and daycares. This is nonsensical and severely detrimental to the quality of life and arguably to the long-term public health of these communities. I would like to call on the Commission to enact common sense rules that limit the proximity of these facilities to the places where people live, learn, and play. Don't wait on the legislature to take action on this. We'll all be old and gone before change comes from that body on this issue. Please research substantive rule changes at the agency level that can solve this issue. And thank you for your time.
Thank you, Mr. Williams. I appreciate your comments. Commissioner Janeka, any reactions, questions, comments?
Thank you for the comments.
Ms. Smith, who's next?
Charles Crook.
Good morning, Mr. Crook.
Good morning. Can you hear me?
I can.
Very good. Well, my name is Charles Crook, Mr. Chairman and General Counsel and Commissioner Janeka. I represent the No Neighborhood Concrete Plants. We have actually been in front of you a while back, been at many of these Zoom meetings. We object to the amendment just on the basis of allowing silica sand to be released unchecked to the environment, but I'm also going to come at a different tack. A lot of other people are talking about silica, but I'd just like to say as a licensed professional civil engineer with 44 years of experience, owner of a civil engineering consulting firm in Texas, I'm required to abide by federal, state, local regulations regarding permitting projects. And in 44 years, I have never seen a one-size-fits-all permit similar to the standard permit for concrete batch plants. For development projects that are within the city limits, the city rules and regulations established to protect the general public on site-specific basis. However, projects that are outside the city, like the Bosque Solutions plant, especially those outside the ETJ of cities, there are fewer rules and regulations to protect the general public. House Bill 3167 was implemented by the state of Texas September 2019. There are many aspects of this bill that are now directly impacting the permitting of concrete batch plants in areas which are outside of the city limits, yet inside the ETJ. Specifically regarding concrete projects located within the ETJ, the county no longer has the authority or responsibility of reviewing the construction site plans. This is now relegated to the associated city. We respectfully request that TCEQ consider the implementation of references in the standard permit to the requirements of this new House bill. This would cause the permit to be more protective of the citizens of Texas. You have the responsibility to use your power to implement site-specific rules and regulations for sites outside of the city limits. Without that, there is virtually no protection for the citizens regarding these batch plans. We respectfully request that the Commission table item number 38 for further consideration of additional modifications before approving this item. If item 38 is passed as written, it's morally incorrect, in my opinion. As it is written, it leaves the door open to those individuals who would be heartless enough to build a concrete batch plant adjacent to an established residential neighborhood or next to child care areas or kindergartens. Under the proposed amendment, there is virtually no protection regarding distance setbacks or protection from silica sand particulate matter. We implore the Commission to table this item and consider further protection and language, especially for the concrete batch plants proposed to be outside of protection of the city limits or ETJ rules and regulations. Other agencies have made recent changes to protect the citizens of Texas. We please ask you to initiate protection for Texans. We applaud the Commission for denying Bosque Solutions permit and ask the same wisdom be extended to the entire state of Texas. We do thank you for your time to listen to our opinions on this matter.
Thank you, Mr. Crook. I appreciate your comments. Commissioner Janeka, any thoughts or questions at this point?
Thank you so much for the comments.
Ms. Smith, who's next?
Adrian Shelley.
Good morning, Mr. Shelley.
Good morning. Adrian Shelley here with Public Citizen. Mr. Chairman, Mr. Commissioner, it's good to see you all in person again. I appreciate all of the efforts that the Commission is taking to accommodate everybody to speak on this issue and to engage in this rulemaking. And, you know, on paper, this might be an approach that makes sense, you know, looking at this as a clerical error, as a technical correction. But I don't think it makes sense in the context that we are in this state right now. And that's what I want to focus on here. Since 2012, we've had 800 batch plants permitted. We've had significant growth of the industry, including, you know, folks coming in from outside of the state, from outside the country, and mining our resources for export. There's been a real change in how this industry has operated since 2012. And there's been a real change in how the public understands and engages with this industry. I've worked with the public on this issue since before 2012. I know how the public is interacting with these facilities, and you all do too, right? You gotta look at the context. If you cannot undertake a clerical rule correction without hundreds of affected members of the public objecting and raising, you know, really significant substantive issues on the approach, right, then there's a problem. And you've got to acknowledge that there's the problem, right? And you have the support to fix it. You had 20 senators and representatives ask you to slow this rulemaking down, to undertake a more thoughtful rulemaking. You've got hundreds of members of the public asking you to slow this down. You've had some pretty significant legal analysis of the approach to the rulemaking. You've had, you know, significant substantive issues raised all over the state. You've got the support to do this right? It's there. The legislature, you know, Corey Williams said it. They can't get anything done right now, but they support you in this, right? Look at the interim committee recommendations, the House Interim Committee report, you know, the APO Interim Committee, right? Look at all of the legislation that was filed, you know, and the good hearings that were held. It wasn't as if there was significant opposition from members of the legislature. They just can't get anything done right now, right? So you all have the support. You've got the legislative support, you've got the public support to do this right. And you've got the sunset review coming up in the next legislative cycle, right? And so this is the last thing I'll say, and I'm saying it as much for everybody who's listening and everybody who's in the room today, right? If the TCEQ lacks the authority to do what needs to be done, that authority has to come from the legislature via the public. And the sunset review process is the right place to do that, right? We believe that you all are up here using all of the authority that you have to do as much as you can to be protective of public health and the environment. We really do believe that you're using the authority that you have. But we understand, or at least we interpret a lot of what's going on as a lack of having the necessary authority. And we want to get you there, right? So I think that's what this is about. And I think taking a step back, doing this a little bit more thoughtfully is going to be an excellent first step in a process that will get you the authority you need to do these things right. Thank you.
Thank you, Mr. Shelley. Appreciate that. Commissioner Janeka, any comments or questions?
Thank you very much for the comment. Not at this time. Appreciate it.
Thank you, Mr. Shelley.
Thank you.
Ms. Smith, who's next?
Clifford Kaplan.
Good morning, Mr. Kaplan. Thanks for being with us today.
Good morning. Thank you for your time and attention to this. I won't reiterate. There's so many great points have been made about the process, flaws in the process, with regards to the data going all the way back 20 years, the inequities of how this industry is impacting folks, and also the ubiquitous of how it is impacting everybody, but sometimes it's concentrated in disadvantaged communities. I guess I just want to simply point out that if it was a clerical error in 2012 that caused this I guess, screw up, then that to me suggests that it's time to be deliberate and thoughtful and not rush this through. And that's exactly what the staff has done in this case, is that, you know, like has been said, 24 actually, Adrian I think said 20, but there's actually 24 senators and representatives, both parties requested an extension to the public comment period so that more study could be done, and that was denied by the staff. And there's just no reason to rush this through, particularly when what set it off, at least allegedly, was a clerical error. So let's be deliberate, let's take our time, be thoughtful, wait for Commissioner Lindley to come back to be able to weigh in as well. There's just no reason to go pedal to the metal on this. So I thank you for your time, and I hope that you will either deny the permit or take no action so that more information can be considered. Thank you.
Thank you, Mr. Kaplan. We appreciate you being here. Commissioner Janeka, any questions, comments at this point?
Thank you very much for that comment.
Ms. Smith, who's next?
That completes my list of people that have signed in asking to address the commission. We have a number of other individuals that signed in who just simply asked not to address the commission, and they will be noted for the record.
Okay, thank you. I appreciate that. And that will take us to Public Interest Council.
Good morning again, Vic McWhorter, Public Interest Council. OPIC's recommendation is to not move forward with this item today. We have two grounds for this position. One relates to transparency and promoting meaningful public participation. The second relates to substantive questions that remain regarding the protectiveness review underlying the permit. First, the transparency and public participation concerns. When the proposed amendment was published for comment, the only information given was that this exemption had been inadvertently omitted in 2012. And the purpose of the amendment is to address the inadvertent error and put the exemption back in the permit. But we think more information should have been provided to the public at the time of publication as to why the agency deems the permit protected with the exemption reinserted. In OPIC's opinion, it was too conclusory a proposal to say nothing more than there was a protectiveness review conducted several years ago and everything is fine. Commenters have described this as an opaque public communication strategy, and OPIC would have to agree with that assessment. What the public wanted to know about and comment on was the substantive analysis that was done on speciated particulate matter, and particularly regarding crystalline silica, so there could be an informed dialogue between the agency and the public on the pertinent question of whether the permit is protective of public health. That is the pertinent issue. not whether the dropping of the exemption language in 2012 was just an administrative clerical error that is just being fixed. There's a very important underlying substantive issue. People wanted to see and have the opportunity to comment on the agency's entire justification today in 2021 for the conclusion that the permit is protected with respect to all speciated particulate emissions. In OPIC's experience, registrations under this permit collectively cause more comments of concern and general negative reactions from members of the public than any other permitting matter we as an office routinely see. Against this backdrop of the high level of public discontent with these facilities, we would hope there'd be a communication strategy to clearly spell out all work done to show that any permit issued is protective and to allow the public a meaningful opportunity to review any recent work and comment on it. Members of the public who filed comment have detailed their concerns about various aspects of the 2012 modeling. Any more recent estimates or work done that justifies the conclusion of protectiveness were not made available at the time of proposal of this amendment. To the extent any look at respirable crystalline silica was recently done that purportedly supports the conclusion of protectiveness, it was only made available to the public now in the RTC, in the agenda backup materials. There's been no meaningful opportunity for the public to review the estimates stated at page 17 of the RTC, and no opportunity to file written comments challenging the validity and reliability of the estimates or underlying assumptions. Based on the statements made in the RTC, it is now known with certainty for the first time after the public comment period has expired, there's been no modeling done to show whether emissions from a permitted facility would be below the crystalline silica effect screening levels. Because the public has not been given an opportunity to examine the estimates done by the agency to support the conclusion of protectiveness before the deadline passed for public comment, OPIC's opinion is there has been no meaningful public participation opportunity. Second reason OPIC cannot support the amendment today is that it seems, from our perspective, substantive technical questions remain dissolved or remain disputed or unresolved. For example, are the respirable crystalline silica emissions estimates recently made and discussed at page 17 of the RTC accurate and reliable representations of conditions at batch plants, since they are estimates based on other estimates and assumptions? Would measuring and modeling of speciated particulate matter, including crystalline silica emissions, provide more accurate and reliable information to support a protectiveness review conclusion? Have speciated particulate matter emissions from stockpiles and roads been properly considered in looking at fugitive emissions? Or sand stockpiles, have their varying sizes, varying levels of crystalline silica content, and varying levels of moisture content been properly considered, given that the permit, when issued in 2000, associated a stockpile area size of 1.42 acres for a plant operating at maximum capacity, and that could be located 50 feet from someone else's property? That background level has been properly considered. In conclusion, OPIC would prefer that this matter be remanded for a more thorough protectiveness review to include modeling of speciated particulate matter, including crystalline silica, or at a minimum, a continuance and a reopening of the comment period so the public has the opportunity to submit further written comment on the ED's recent emission estimates and any other information that was in the RTC that was not previously available to the public. Thank you. Those are my comments today.
Thank you, Mr. McWhorter. I appreciate your comments. Commissioner Janek, any questions for Mr. McWhorter?
I really appreciate the comments and would like to discuss with someone from OGC or from OPIC staff, specifically after today, after the meeting, the concerns you had relative to the findings about stockpiles, where there may be an opportunity to try to revisit that specifically. That's a unique question I'd like to explore with you further, Mr. McWhorter, but right now I appreciate the comment. Thank you.
Thank you.
Do you want to do that now, or?
I see that as a Well, let me step back and comment on Mr. McWhorter's comment and say I appreciate both points you raised, and I think I'm in strong agreement with the concerns you raised specifically towards the perceptions of transparency of our agency's process and how we arrived here today. As for the second big tier issue, the substantive questions that remain, I think kind of an artifact of the transparency issue where in my opinion, I don't know I agree with Mr. McWhorter. I don't think that our staff got quite to the level that I had hoped in my hypothetical before we came here to see the record today. I would have loved to have seen exactly what Mr. McWhorter hinted at, the detailed speciated analysis, and I think that was done satisfactorily, but in other supporting documents that our agency, and unfortunately typical fashion that state agencies are just so prone to and so good at in posture, it's there. The work's been done. We don't do a great job of circling back, trying to collect it all together, making a very concise and clear and easy to understand, not opaque explanation to the public. I spent quite a bit of time before today trying to review and familiarize myself with our agencies. Well, there was one document in response to a comment from a questioner early on in the questions we heard, asking if any of ED staff have given us graphical descriptions of error interpretations. My mind immediately went to the report that I've spent a lot of time with over the last week, and that was the 2020 report on crystalline silica, ambient air monitoring and evaluation of community health impacts near aggregate production operations. And it was in that December 2020 report that was available on our agency's website where I found a lot of the answers to some of the specific questions that Mr. McWhorter raised. And I agree, are substantive open questions that reviewing just the open window of public review and discussion that opens from public comment of this rule, the standard permit revision, to today and the executive director's response to comments. I think that we unfortunately failed to bring in a lot of the really great data and finding the evidence that we've consolidated into that report as an example that goes back to how our agency handles all emissions of concern. We have I want to make sure I get all the words, and I'm trying not to use acronyms, a development support document dated October 8th, 2009, and a 24-hour REV development support document dated December 11th, 2020. These, as I've been reviewing them, really, I think, best summarize our agency's science behind where we reach these levels and limits, and what was simply a few comments in response in the public comment in this backup before us today, I think really pointed to and speaks to this much greater, one's a 19-page document, the other's a 77-page document, a much deeper factual and written analysis that our agency has conducted on these constituents. So I think in terms of my level of comfort and concern to the second tent pole that OPIC raised in their comment, I'm pretty comfortable moving forward today, given that level of analysis that our agency really rests all the standard permits on level of transparency. I couldn't agree more. I think that given the
can I interject?
Yeah,
When you say
yeah,
you're ready to
stop.
move forward, you're talking move forward with what specifically?
I would be comfortable with the finalizing the proposed revision of the standard permit to bring us back to the point we departed from in 2012, and I see it as I do see it as a clerical error, given that the 800 plants that have been issued, or the 800 permits that have been issued, are the biggest evidence of any in terms of our agency posture and process for handling these standard permits didn't change one bit. And I find the ED's explanation in response to that comment particularly compelling, in terms of there was no discussion and no notice to the public in 2012 when those changes were made. And as we can see in the decision from the single instance that a permit was not issued, when that fact is brought to our agency's, our commission's attention, I think that we've demonstrated that we will not issue the permit. There were 800 permits where no one found and pointed out the fact that what really, in my case, that makes a good argument, is just a clerical error and a inadvertent omission, and where we didn't notice the public and get into any description or detail or discussion towards removing that exemption of a permit for a different area. And also given the fact that literally every other standard permit for which our agency offers an opportunity for permittees to come in and obtain a authorization to operate, we provide that explicit exemption. That it is not included in this one, that it is included in every other one, that our agency processes didn't materially change in response to the removal in 2012, is all a very strong basis and argument in my mind that it's a process problem, not a substance problem. But I appreciate the opportunity this has given the opponents in the concerned public to come forward and to raise the issue raise the flags on exactly this issue where they have growing and increasing concerns. And I think we're getting better understanding of the impacts on fence line communities as we see more of these facilities being built in our state and in our country. And I'm impressed with how broadly staff really did search to grab other data and other actual evidence where we have studies, where it's out there in a defensible state that we can incorporate into our agency's regulatory review and try to balance out where will the potential harm to the public fall numerically. And I think some of the setbacks and some of the controls that are built into the standard permit reflect exactly that, because it comes so close to the line. When you look closely at our toxicology division's analysis of that ESL number, it is precisely at the cancer tolerance level that EPA sets us on a course to calculate and determine how the standard permit is determined. And so for our agency today to act on this standard permit for this one class of industrial activity, I feel would put us on very unsteady grounds in the eyes of the legislature, in the eyes of the Sunset Commission, where we're just about to undergo review, and in the eyes of the 181 minus 23 members of the legislature who didn't offer comments for us today. I think they may have other views and may want to weigh in a way that for our agency to act what from in the legislature's eyes may be a arbitrary and inconsistent way for one permit category over all the others puts us in a uniquely perilous spot in terms of being able to hold on to that position and retain that authority in statute.
That was a lot. Appreciate your comments. Largely agree. I'd like to share my thoughts. I did want to give the executive director's staff an opportunity to respond to some of what they heard this morning, and especially the comments from the Office of Public Interest, which echoed in a lot of cases the comments we heard from the interested persons about questions around substantive technical issues. So is there somebody from the executive director's staff who'd like to offer some thoughts on the points that Mr. McWhirter made? You might check your mute button. Not sure that's...
Good morning, Chairman, Commissioners. Can you all hear me?
Yes.
Thank you. This is Sam Short, Deputy Director of the Air Permits Division for the Executive Director. In response to the comments, we did evaluate, and as Commissioner Janeka had mentioned, we utilized all the resources that we had available with our toxicological division to try to address the concerns with crystalline silica, although it was not explicitly a part of this this action. This action was to add back in the language that was inadvertently removed in 2012. And although that it was limited to that scope, we did try in the response to comments to provide the technical justifications and information that the public was seeking with regards to crystalline silica.
Thank you for that, Mr. Short. I do have another follow-up question. Is there any, to your knowledge, any information that was submitted on emissions data or ambient air data monitored or modeled concerning crystalline silica that was provided by any of the commenters or any of the interested persons in this case? In other words, is there a competing data set or additional data set that you're aware of? generated by any of the interested persons that was submitted on this item.
Several individuals did comment regarding crystalline silica and also made rough estimates of their own, but no actual data sets that I'm aware of were provided. Most of it were also based on hypotheticals and estimates.
Okay, thank you, Mr. Short. I appreciate that. Well, Commissioner Janeka, to cut to the chase, I'll provide some explanation, but to cut to the chase, I'm with you. I do think that we should move ahead with this item. What concerns me and looms large is sort of the programmatic effect. And I do believe that this was an error, that it was inadvertent. I think you pointed out that if it were intentional, it would have been noticed in 2012, so the public could be made aware and comment, that we were intending to drop the exemption from those distance and emission limitations. In my mind, that's some evidence. The other thing that came up in conversations during our consideration of the permit matter is what is the effect of these distance and emission limitations. And I think arguably the effect could be thou shalt not emit a molecule of crystalline silica, whether it poses a risk or not. And so I'm concerned that there's a real risk by taking no action. We allow a situation where there could be arguably an effective permitting moratorium on concrete batch plants, and that seems to be not a place that we want to be. And then in terms of the question of is this protective? That is the central question. And I agree with Mr. Shelley. We do have a problem there. The industry has grown, has changed. The public is a lot more interested and concerned in the effects of crystalline silica, and just by virtue of the comments that we've received on this item, including everybody who, and I'm grateful for them showing up and sharing their thoughts today, they're letting us know that we have a problem with this. But I'm not sure that possibly creating a permitting moratorium is the answer. And I believe that the protectiveness review in 2012 wasn't as thorough as one we would do today. But I think that it was adequate and remains adequate. A lot of what may become sort of express, I think, was built into the professional judgment that underpinned that. And it's my belief that the crystalline silica really is an occupational hazard, but doesn't travel in threatening quantities outside the fence line if you're complying with the requirements of the standard permit. So that's my sort of reaction to many of the arguments, and there's just not enough time to address every argument that we heard today. But that's kind of high level where I stand. I have concern about the program and how we continue that. So I really see this exercise in two pieces. I think that we ought to move forward with the action today, and then figure out how to better address and engage the science, and then also to engage with the interested community members to come to a common understanding of what the science means and what is protective. So that I see as a separate challenge, and I don't feel like we have the luxury of pausing or continuing right now to have that conversation. I think it's going to be a long one. It's going to require a lot of work, and I think it could perpetuate a moratorium on the operation of these plants. So if I believed that there were a risk to public health, I would view this differently. I don't. I think the protectiveness review in 2012 was adequate. I think we need to back that up going forward. But for purposes of today's action, I think I'm ready to move forward.
I think that I'm in agreement, and I'll only observe another thought that I had, and that was that largely much of the public dissatisfaction, the apparent public dissatisfaction with the process that we've taken in getting this standard permit update before us today, I think it reflects the necessary reality of a state agency trying to act very, very quickly in the moment. This was a bit of a crisis for us in terms of our practice, agency practice in life and reality did not necessarily comport 100% with what's our practices laid out on paper in our rules. And so getting quickly into that consistent posture is really critically important for a regulatory agency that issues permits. I agree with you 100% that to remain in the legal posture of this one permit retaining applicability requirements of the standard of the emissions table at issue in the exemption here leaves us in a de facto circumstance where there is a non-functioning standard permit opportunity at our agency, and I consider that an inconsistency problem. I consider that a worth addressing, but I agree with you wholeheartedly as well in recognizing the open concern that now needs to be addressed in the opportunities before the legislature, before the Sunset Commission, before the venues where our agency comes to participate alongside the members of the public and stakeholders that we've heard from today. We're all going to continue speaking and engaging on this issue. I think our agency is just rightfully in a very compartmentalized box, and we're given explicit directions and expectations from the state and how to, and conversely from the federal government in terms of their expectations for how we have to run that program. And we're constantly engaged in that push-pull. And this falls in that same space where there is significantly more apparent public dissatisfaction with this area of permitting. I recognize that, and I want to echo your comments and thank the members of the public who came today and took the time to call into our hearing or appear here today. It's never a convenient or an easy process to try to understand and engage with your state government. So I certainly appreciate that, but I think that's where I am today as well.
Thank you, Commissioner Janeka. Well, without belaboring it, I think we're ready for a motion.
I move that we adopt the amendments to the air quality standard permit for concrete batch plants and the ED's revised response to comments.
The motion has been made. I second it. All those in favor say aye. Aye. The motion carries. Ms. Smith, please call the next item.
Item 39 is the discussion of the Office of Public Interest Counsel's annual report. The Public Interest Counsel is here to present the item.
Well, good morning again, Mr. McWhirter.
Good morning. Texas Water Code Section 5.2725 directs OPIC to report to you annually concerning OPIC's performance for the preceding year and other items as specified by the statute. The written report submitted for your backup materials is intended to satisfy that statutory directive. At pages 5 and 6, the report lays out the performance measures for OPIC that the Commission adopted in 2012. The 4 types of matters we are required to measure are environmental matters, district matters, rulemaking, and enforcement. As discussed in further detail at page 7 of the report, OPIC met its performance measure goals for fiscal year 2021 for these 4 categories. Thank you for the opportunity to report about OPIC's work, and I welcome any questions or feedback you may have.
Thank you, Mr. McWhirter. I don't have any questions, but I appreciate the report, and I really appreciate the really top-notch work that you and your team turn in agenda after agenda. I rely on it heavily and really appreciate the quality of the work. So thank you. Commissioner Janeka?
I echo those comments, and I'll only add that I was glad to note a description of the almost obtaining an emergency or an expert witness at the emergency pace that OPIC needs to rely on in participating in contested case hearing. I realize that one case settled, but it shows that at least the process works, and I look forward to seeing that followed through fully. Appreciate that.
Well, thank you again. No action is necessary on this item, so Ms. Smith, I'll ask you to please call the next item.
Item 40 is the consideration for publication of and hearing on the proposed repeal of certain sections of 30 Texas Administrative Code, Chapters 308, 314, and 315, and the adoption of new sections of 30 Texas Administrative Code, Chapter 305. The Executive Director's staff is here to present this item.
Good morning.
Good morning, Chairman Neerman, Commissioner Janeka, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I'm Laurie Fleet with the Water Quality Division. With me today is Celia Castro with the Environmental Law Division. The proposed rulemaking would repeal Chapters 308, 314, and 315 and repropose these rules within Chapter 305, Subchapter P, with the exception of Subchapters C and J of Chapter 308, which would not be reproposed because these subchapters were determined to be obsolete. The rulemaking would also adopt by reference 40 Code of Federal Regulations, Part 125, Subpart N. During the 2019 quadrennial rule reviews, 30 Chapters 308, Subchapters C and J were identified as obsolete. Additionally, the Executive Director identified several rules related to the Texas Pollutant Discharge Elimination System program that would be more appropriately consolidated with Chapter 305, Subchapter P. These rules include Chapters 308, 314, and 315, which contain adoption by reference of federal regulations similar to Chapter 305, Subchapter P. Consolidating these rules would improve the overall organization of TCEQ rules related to the TPDES program. Lastly, the Executive Director identified a federal regulation related to cooling water intake structures at oil and gas facilities, which is 40 Code of Federal Regulations, Part 125, Subpart N, that was not previously adopted when 40 Code of Federal Regulations, Part 125 was adopted in Chapter 308. This rulemaking would adopt this additional federal regulation by reference. Staff respectfully request approval for the publication of and hearing on proposed repeal of Chapters 308, 314, and 315 in their entirety, and proposed new sections 305.542 through 305.544 in Chapter 305. Staff additionally requests authorization to make non-substantive revisions to comply with Texas Register requirements. Thank you, and we're available to answer any questions.
Well, thank you, Ms. Fleet. I have none. Commissioner Janeka, any questions?
No questions today. Thank you.
Thank you. Ms. Smith, is anyone signed in?
No.
Mr. McWhorter, what do you think?
OPIC recommends approval for publication of and hearing on the proposed repeal of Chapters 308, 314, and 315, and except for obsolete Chapter 308, Subchapter C and J, reproposal of these rules to consolidate them in Chapter 305. We support publication of all proposed changes as recommended by the Executive Director.
Thank you. I do too. Commissioner Janeka, the repeal and consolidation makes sense. I think I'm ready for your thoughts or a motion.
I'm so much in agreement, I'll just move on to the motion. I move that we approve the publication of and hearing on the proposed repeal of sections of 30 Texas Administrative Code Chapters 308, 314, and 315, and proposed adoption of new sections of 30 Texas Administrative Code Chapter 305, as recommended by the Executive Director.
The motion has been made. I second it. All those in favor say aye. Aye. The motion carries. Ms. Smith, please call the next item.
Item 41 is the consideration for publication and hearing on the proposed repeal of 30 Texas Administrative Code Chapter 321, Subchapters E, F, and L, and Chapter 351, Subchapter D. The Executive Director's staff is here to present this item.
Good morning again.
Good morning again, Chairman Neerman, Commissioner Janeka, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I'm Laurie Fleet with the Water Quality Division. With me today is Hollis Henley with the Environmental Law Division. The proposed rulemaking would repeal Chapter 321, Subchapters E, F, and L, and Chapter 351, Subchapter D, which were determined to be obsolete during the 2019 quadrennial rule review. Chapter 321, Subchapter E, regulates discharges from surface coal mining, preparation, and reclamation activities. Subchapter F regulates discharges from the shrimp industry. And Subchapter L regulates discharges from motor vehicle cleaning facilities. These subchapters are obsolete because the Memorandum of Agreement between TCEQ and EPA concerning the National Pollutant Discharge Elimination System prohibits TCEQ from issuing authorizations under these subchapters. TCEQ authorizes these discharges under either an individual permit or general permit which comply with all necessary National Pollutant Discharge Elimination System requirements. Chapter 351, Subchapter D, designates the Rio Grande Valley Pollution Control Authority as a regional wastewater service provider for the lower Rio Grande Valley regional area. This subchapter is obsolete because the Rio Grande Valley Pollution Control Authority no longer exists, nor are there any wastewater permits issued to any regional system in this regional area. Staff respectfully request approval for the publication of and hearing on proposed repeal of Chapter 321, Subchapters E, F, and L, and Chapter 351, Subchapter D. Staff additionally request authorization to make non-substantive revisions to comply with Texas Register requirements. Thank you, and I'm available for any questions.
Thank you again, Ms. Fleet. I have none. Commissioner Janeka?
No questions. Thank you. I failed to mention on the previous rule item, I was very pleased to see the changes that were proposed that will help clarify, I think, and improve the readability of the rules. But only thing I want to chime in and add is just I'm grateful that this and the previous rule item I heard before us, I think it's a great example of the changes that you can have at the agency that you don't fully see until years and years later. It's just a good continued example of your arrival at our agency. I remember when you were appointed initially, pretty shortly after was the call from above to redouble our efforts to the quadrennial rule review. And I think both of these rulemakings are exactly what we were hoping to get clean up and moving forward. So.
It is a statutory requirement, and it's always good to comply with statutory requirements. And it is a terrible chore. I don't know. Maybe somebody enjoys it, and God bless them. But it's important and it's useful. So I'm glad we're doing it. Ms. Smith, has anyone signed in to speak on this item 41?
No.
And Mr. McWhirter, what do you think?
OPIC recommends approval for publication of the proposed repeal of obsolete sections of the Commission's Chapter 321 and 351 rules as presented by the Executive Director.
Thank you, Mr. McWhirter. I agree. And thanks again for the rule team's work on this. I don't have anything else to add. I think I'm ready for a motion or additional thoughts.
Yeah, I move that we approve the publication of and hearing on the proposed repeal of 30 Texas Administrative Code Chapter 321, Subchapters E, F, and L, and Chapter 351, Subchapter D, as recommended by the Executive Director.
The motion has been made. I second it. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, please call the next item.
Item number 42 is the consideration of the agency post-incident response actions related to the February 2021 severe wet winter storm, including plans to evaluate factors that impacted public water system response and recovery actions. The ED staff is here to present this item.
Good morning.
Good morning, Chairman, Commissioner, General Counsel, and Public Interest Counsel. For the record, I am Brittany Wortham-Teakle, Special Assistant for the Plan and Technical Review Section in the Water Supply Division. I'm here to provide the monthly update for the agency's after-action review of Winter Storm Uri. The project has entered a review and deliberation phase. We are currently focusing on sorting and reviewing the information gathered through the survey, roundtable discussions, and literature review portions of the project. While performing these tasks, the project team is also having regular discussions to begin identifying potential recommendations based on the information reviewed and experiences during the storm. The team has begun reaching out to other areas within TCEQ for program-specific discussions about the feasibility and effectiveness of potential changes to TCEQ rules and programs based on the information found through the survey, roundtable discussions, and literature review. These conversations will also assist the project team in understanding the steps necessary for developing and later implementing potential recommendations. The project team continues to focus efforts on coordinating additional training events through the fall. The project team is assisting in planning upcoming regional workshops relating to the new emergency preparedness plan requirements, which will also include discussions on relevant resiliency topics. The team is also responding to requests from outside organizations for training relating to the emergency preparedness plans and water system resiliency. The project team is continuing to work with EPA's Water Security Division to deliver a virtual workshop which will be held on November 10th with an emphasis on power resiliency. We have posted registration for this training on our project webpage and are requesting other areas of the agency to assist with advertising this workshop as well. That concludes our monthly update. We welcome any feedback that you may have, and I am available to answer any questions.
Thank you, Ms. Wortham-Teakle. I have none at this point. Commissioner Ginecca?
I appreciate the report. I don't have questions right now.
Ms. Smith, has anyone signed in to speak on this item?
No one has signed in.
Thank you. And Mr. McWhirter, what are your thoughts?
I don't have any questions. I appreciate all the work that's being done in the report.
Likewise, it's a massive undertaking. It's an important undertaking because I think we're going to need resiliency more and more going forward. No action is necessary on this report. So thank you again. And Ms. Smith, I'll ask you to call the next items.
Items 43 and 40 through 46 are for closed session, but the commission will not meet in closed session today.
Thank you, Ms. Smith. The time is 11:54 and we are adjourned.